Okay, now we can start, and everyone can see us on YouTube.
Sure. Hello. Good afternoon, everyone. Welcome to this presentation. My name is Edmund Kronenburg. I'm an arbitrator and a litigation and arbitration counsel from Singapore, from the firm of Braddell Brothers. I'm very pleased to be speaking with you on this presentation, all the way from Singapore. And it's night here. We all now are able to connect from different parts of the world and share ideas. So I think there is a small upside to the situation that we're all facing with the lockdown. And I hope to be able to share some thoughts and ideas on international arbitration with you this afternoon or this evening, wherever you are. So let me just start with the presentation. The topic that I'm going to be speaking on is strategies for organizing an international arbitration to maximize enforceability as well as time and cost efficiency. So that's a mouthful. What it basically means is, how do you do an international arbitration such that it is as cheap as possible, as fast as possible, but making it as good as possible. And to that point, here's a very commonly seen diagram. You see these three circles: good, fast, cheap, and you can only choose two. Because if you want good and fast, you're not going to get cheap, it's going to be expensive. If you want good and cheap, then it's going to take time. If you want fast and cheap, then it's probably not going to be good. You're going to have a low quality product. And in arbitration, we all want, if possible, to get something that's good, fast, and cheap to meet all three criteria. It's easier said than done. And a lot of people say it can't be done, but we can try our best to do that. When I say good, what do we mean by good? Well, you want an award, which is the product of the arbitration, that's correct. You want the right result. And you want, at the end of the day, an enforceable award. There's no point getting an award that's correct, that's reasoned well, that's in your client's favor, but can't be enforced against the losing party, right? So how do we get an arbitration that comes as close as possible to good, fast, and cheap? That's what we're going to be discussing today. So here are some obvious big picture strategies. It's obvious that you want to avoid legal and procedural minefields. You don't want to get bogged down in arguments, for example, over where to have the case. What can be decided by an arbitrator, what can't be decided by an arbitrator, because it's, let's say, outside his jurisdiction. You don't want to get bogged down in things like that. You want to get to the end of the dispute and who's right and wrong in the dispute and who should pay whom in the dispute. Some other big picture strategies are to make it easier for arbitrators to write awards. What do I mean by easier? A lot of people think that being an arbitrator is a very easy thing. It's not. You have to consider all the law that applies to the dispute. You have to consider all the facts that apply to the dispute. And you have to do this in a way that you show the parties that you're taking everything in and that you are being fair to the parties, because the process through which you arrive at your decision, your award, has to appear fair to the parties. Justice has to be done, but it has also to be seen to be done, especially by the people who are paying the arbitrator to do that job, to decide the case. So you want to make it as pain-free, if possible, for the arbitrator to write the award. How do we do this? We'll talk about this a little bit more as we go on. Another obvious big picture strategy to save time, or to at least limit the amount of time that you're going to take for an arbitration, is to set an overall time limit. To say this arbitration must be done within 1 year, or this arbitration must complete within 18 months or 2 years, whatever you think is reasonable in order to get to the end of the dispute in a correct way. And the last point here, another obvious big picture strategy is cutting out major time and cost expenditures to the extent you can. For example, long flights to get to arbitration hearings, booking hotels for 16 witnesses and the lawyers and the tribunal, fancy tech setups where you have a lot of screens, a lot of monitors, a lot of transcription, and a lot of cost involved. Do you really need all of that? And sometimes you do. I'm not saying that these are always unnecessary. In fact, a lot of the time they can be beneficial, but there are some times that you don't need these things. And now with the advent of remote hearings, virtual hearings, maybe some of these things can be streamlined and a lot of the cost can be cut out. So let's explore how these big picture strategies can feature specifically into an arbitration process. We're going to be talking about these 7 things this evening. We're going to be starting with the arbitration agreement. We're going on to choice of seat, institution, choice of rules. We'll talk about what is known as PO1, Procedural Order Number 1, and the arbitration timetable. We'll talk about inviting agreement between the parties wherever possible, list of issues, using witness statements, and finally, we'll end up with the hearing and post-hearing procedures. Now, here's a warning. Knowledge of these strategies can be used for good and bad. It's a bit like martial arts. You can use them for good or you can use them for evil. So the strategies that we'll be discussing today, for those of you who would like to think of them as a bit more sexy than they are, the strategies can be used to speed up an arbitration, to make an arbitration more efficient. The same concepts and strategies, if applied in reverse, could well be used to slow down an arbitration or to make an arbitration more difficult or to stifle enforcement of an award at the end of an arbitration. So I'm not imparting these strategies for those purposes. I'm imparting these strategies in an effort to try and speed up and improve arbitrations. This is a typical arbitration process. It's not every arbitration is exactly the same, but this is a typical one. And I'm just going to walk you through this in case you might not have had the actual experience of being in an arbitration yourself. So there's a commencement phase right at the top where a request for arbitration or a notice for arbitration is lodged, let's say, with an institution, or it's served on the other side, and there could be a response from the other side. And then there is the constitution or the formation of the arbitral tribunal. This arbitral tribunal could be a sole arbitrator, it could be a panel of 3. And at that juncture, after the arbitration, after the tribunal is formed, the tribunal will normally call for a case conference or at least engage the parties to figure out how they want to run the arbitration, what's going to happen next in the rest of this arbitration. And that's normally put into something called a procedural order number 1 with a timetable. After that, based on what procedural order number 1 says, you get into the submissions. And I use the word submissions as opposed to pleadings because in, let's say, the English common law system or the Singapore common law system, a pleading is just a very bare statement of material facts, the main facts of the case, without full legal argument, without the evidence supporting those statements. So you could have submissions in the pleading style, or you could have submissions in a memorial style, which is a lot lengthier, a lot more detailed, gets into the evidence, gets into the facts, and could even include witness statements and expert reports annexed to the submission, to the memorial. So the parties have to decide, do we want something in the pleading style or the memorial style or a hybrid of the two? It really depends. The next phase is usually what we would call document production. To common lawyers, the term discovery might be more familiar, but document production is probably a better term. It's a request by one side to the other side to produce certain documents that have a material outcome on the case. And the tribunal will have to decide if these documents ought to be produced. A party could voluntarily produce these documents, or the tribunal decides whether to order a party to produce these documents. The next phase really depends. You could get back to another round of submissions, which could be pleadings and memorials, or you could then go to the pre-hearing phase. And this might include the exchange of witness statements, statements made by a witness giving his or her direct evidence in support of a party. You could have opening statements from the parties outlining what their cases are to the tribunal, to make it clearer to the tribunal what issues the tribunal has to be deciding in the hearing. We then get to the hearing. That's when the witnesses come. The witnesses get examined by counsel, by the tribunal, and perhaps some submissions are made orally to the tribunal on certain points of law. We then get to the post-hearing phase, where very often briefs, which are another type of submission, are filed to the tribunal to wrap up the evidence that has come out in the hearing, together with the law, to urge the tribunal to find in a party's favor. The tribunal then closes the proceedings, goes away, thinks about the merits of the case. He or she then submits that draft to the institution for scrutiny. Now, this doesn't happen in every institution. In SIAC, there's a scrutinization process. In ICC, there's a scrutiny process as well. HKIAC doesn't have it. Now, I'm not going to say whether scrutiny is good or bad. It does help arbitrators not to make calculation errors and obvious mistakes. So there are plus points, but it also does slow down the time taken for the issuance of the award. The award is then published. It's then released to the parties. And then we get to the enforcement of the award. And a lot of people think the arbitration stops when the award is released. Yes, the arbitration is over at that point in time formally. The tribunal is what we call functus. It's done its job, but that award still has to be enforced. So as far as the parties are concerned, the issuance of the award does not mean necessarily the end of the proceedings. They still have to take that award and try to get payment from the other side. And the other side could voluntarily pay under the award, or the other side might not want to do that. And then you might need to enforce that award against the losing side. Along the way, you can see I've indicated a possible challenge of jurisdiction. This often happens just after the first round of submissions. That's when the jurisdictional challenges need to be made in most systems. And after the release of the award, there might be a challenge to the award to say that it's bad and it shouldn't be upheld as a proper award. Even if that challenge fails, there's still the possibility to challenge enforcement in jurisdictions other than the seat. Those jurisdictions can consider whether they want to enforce the award based on their own laws. All right, so that's a typical arbitration process. And what we're going to be talking about is how to get through this process as seamlessly, as painlessly as possible, without spending too much money. So let's see how that can happen. So let's talk about the arbitration agreement. The arbitration agreement is key to the arbitration. If you don't have an arbitration agreement, as we all know, you don't have an arbitration. And arbitration derives its power from the agreement between the parties to submit their disputes to arbitration. And the agreement also has to be backed up by a system of law. But in many situations, that arbitration agreement is regarded as the midnight clause. It's the clause that corporate lawyers throw in right at the end, after all the commercial terms have been agreed in a contract, the parties are ready to sign, and then the corporate lawyers say, hang on, I think we need an arbitration clause, and they throw it in, and they very often throw it in based on what they've done before. This is obviously not the best way to approach an arbitration clause. If you become disputes lawyers in future, please tell your corporate colleagues not to depart from standard form institutional arbitration clauses, what we call model clauses. Don't change the wording. The wording has been carefully thought out. Don't be too clever and amend the wording because, oh, it's ungainly, it's not nice, I think I can shorten it, it's too long. Please don't do that. A good arbitration clause should specify the seat of the arbitration. It should specify the language of the arbitration. It should specify the number of arbitrators. And in many jurisdictions, it should specify the institution, because in many jurisdictions, in certain jurisdictions, non-institutional arbitration is not upheld. And it should specify the rules to be applied. And these have to work together. You can't, for example, select institution A and ask it to apply the rules of institution B. That would be a problem. You want an arbitration clause that captures the wider scope of disputes, issues, or claims. You don't want something that's very narrow, because framing the clause too narrowly encourages people to say, our dispute is outside the clause. So you, the tribunal, do not have jurisdiction to resolve this particular dispute. The clause doesn't allow you to do that. You don't want that problem. Many arbitration clauses do not state what their governing law is. Now, this is to be distinguished from the governing law in a contract itself, in the overall contract. The overall contract, the matrix contract, might have a governing law of its own. For example, Russian law, English law, New York law. But the arbitration agreement is often treated as a separate agreement from the main contract, and it therefore can have its own governing law. The last thing you want is to get into a dispute over what the governing law of the arbitration agreement is. And the best way to avoid that kind of dispute is to specify what the governing law of the arbitration agreement is. State it and make sure that the arbitration agreement that has been drafted complies with that law. When choosing or drafting an arbitration agreement, an arbitration clause, think of whether the client that you're representing is more likely to be sued or more likely going to sue. Now, why is this? If I'm going to sue someone, I want to make it as easy as possible for me to sue that person in terms of time, in terms of cost, in terms of effort. Making me go far away from my own country to a place that I'm unfamiliar with is going to probably cause issues. So choose a place, if you're going to sue, if you're more likely to sue, choose a place where you can readily, easily commence the arbitration, something that the client is more familiar with. If, on the other hand, there's a high chance at that point in time that the client is likely to be sued by the other side, then you might want to think of choosing somewhere which would pose certain problems for the other side in commencing an arbitration. So as opposed to commencing an arbitration, they might hold out an olive branch and decide to mediate or negotiate before actually embarking on the arbitration process. Right? So it's useful to think about whether you're going to be at the aggressive end or the receiving end of an arbitration. And finally, please do not draft a clause that is pathological. What's a pathological arbitration clause? Here's an example. Well, I'll give you an example, but this isn't the pathological clause. This is a good clause. This is the SIC model clause. I'm going to walk you through this just as an example of the things that they have in there quite quickly. The first is this bit in gray. Any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination. I'm just going to pause there. So as you can see, the scope of the clause is very wide. And then it continues, shall be referred to and finally resolved by arbitration. That's clear. Parties have to go to arbitration. Administered by the SIAC, that's the institution that's mentioned, in accordance with the SIAC rules. So that's the rules that I mentioned, for the time being enforced. Now that, as far as Singapore English law is concerned, means the rules that apply at the time that the arbitration is commenced. It's not the time when the contract was signed. It's the version of the rules applicable at the time the arbitration is commenced. Which rules are deemed to be incorporated by reference in this clause? So the rules are brought into the clause by this wording. The seat of the arbitration shall be whatever it is. The tribunal shall consist of how many arbitrators. The language of the arbitration shall be English, whatever else you may choose. And this arbitration agreement is governed by the laws of Singapore or England or Russia. But at least you state clearly what the governing law of the contract, the arbitration agreement is. So when anyone decides that they want to challenge the meaning of this, or there's a dispute over what this clause says, and somebody says, right, so which lens do we put on? Which glasses do we put on in assessing whether this clause is valid or not? Whether it means something like this or like that? In deciding that, which law do we apply? You don't have to ask any more questions, because the clause itself says this arbitration agreement is governed by this system of law, and then you apply that system of law. This is a pathological clause, as promised. It's completely fictitious. Let me show you the problems it can cause. Any dispute under this contract, so it has to be under the contract. If it's connected with this contract, but not exactly under the contract, is it caught by the clause? Not really sure. That's a problem. Shall be settled by arbitration in Singapore, Russia. Singapore is not in Russia. Russia is not in Singapore. So is the seat Singapore? Is it Russia? And then parties are going to argue over that. Administered by the Moscow Commercial Arbitration Center, which doesn't exist. So somebody may say, oh, this obviously means this center in Russia or that center in Russia. Now, if you go to a center and the center says, hey, yeah, I think that's us. And then they appoint the arbitrator, for example, and one party who probably thinks he's going to lose challenges the arbitration by saying, I do not acknowledge your authority. I don't acknowledge your jurisdiction, Mr. Arbitrator, to resolve this dispute because you were appointed by whatever institution in Moscow, and it's not the Moscow Commercial Arbitration Center. And then you get a problem with jurisdiction. Let's carry on. In accordance with the arbitration rules of the American Chamber of Arbitration, which also doesn't exist. So some people think they can just write any old rules they want, but you can't. You have to actually refer to rules that really exist, which would be applicable at the time of this contract. Well, what happens if those rules don't exist at the time of the contract? Or if the rules exist, but the rules are subsequently amended and improved, you can't take the advantage of those subsequently amended and improved rules because you have said, apply the rules applicable at the time of the contract, apply the old rules, which may not work anymore. So here's an example of something that should not be done. Doing something like this will slow down your arbitration, will bog down your arbitration. What happens if there's a poor arbitration clause? Well, anybody reading a pathological clause would be thinking, well, I think this is a rubbish clause. I think we shouldn't go ahead with an arbitration. Let's go to court. And then the other side will say, no, no, I want to go to arbitration. And the other side will take out an application to stay or suspend those proceedings in favor of arbitration. And there you will have a big fight over where to fight. Do we fight in court or do we fight in arbitration? And that's a fight you don't want because it wastes time and costs. It could also result in a challenge to the tribunal's jurisdiction. One party, as I've explained before, saying, Mr. Arbitrator, that dispute is outside the scope of the clause, so you can't decide it. And if you try to decide it, then I'm going to challenge your decision because you didn't have jurisdiction to decide the dispute. If the clause also doesn't have any provisions as to language, to seat, then the tribunal will have to decide what the language of the arbitration is. And then you might have two international parties, one based in China, one based in India, each arguing we should have this arbitration in Chinese or we should have the arbitration in Indian or in Hindi or in Tamil, some other Indian languages. You don't want that. It's just going to take time that you don't need to spend. If there is no seat specified or the seat is unclear, then the tribunal will have to decide what the seat of the arbitration is. And there again, you're going to have a fight that could easily have been avoided using a clear clause. All of this could result in setting aside applications because, oh, that's not what we agreed to. So the arbitration was not in accordance with what the parties agreed to, or there was a lack of jurisdiction. It could result similarly in enforcement challenges. And all this means time and money unnecessarily spent. So a lot of people talk about saving time and cost in arbitration after the arbitration has commenced. I want to highlight that the number one way of ensuring that you have a fast, good, and cheap, if possible, arbitration all at the same time is to have an excellent arbitration clause. Let's talk about choice of seat, institution, and rules, which goes into the arbitration clause that we just spoke of, but I'm going to get into this in a little bit more detail. So sometimes a client may have a special enforcement consideration. For example, if you happen to be a Russian party investing in Vietnam and there's a dispute and you want to enforce in Vietnam, you don't want to get bogged down. Let's say if an award is rendered in your favor, you don't want to get bogged down in the Vietnamese courts. I always highlight this about the Vietnam International Arbitration Center, because if an arbitration is held there and an award is rendered at the VIAC in Vietnam, you don't have to go through the courts to obtain enforcement. It goes straight to the enforcement agency in Vietnam, and they enforce that award as if it was a court order. It's a lot faster, a lot cheaper. That's a special situation. So there may be special enforcement considerations that you should take into account in choosing your seat or your institution or rules when drafting the clause. Generally, it's useful to look to pro-arbitration jurisdictions where they have pro-arbitration laws and pro-arbitration courts. If you were to cite your arbitration, seat your arbitration in a place that is unfriendly to arbitration, that takes a very restricted view of what tribunals can do and what they can't, and a very strict view of what they can't, then you might face problems at the enforcement stage, or in fact, you might have a set-aside application made in relation to the award. Again, in choosing institutions and rules, think of fast, good, cheap. And some of your considerations could be the following. When you're looking at the cost factor, some institutions are better or in terms of cost efficiency, in terms of being cheap for certain size disputes. If you think your disputes are going to be, let's say, under $1 million, some institutions are very cost effective under that amount. If you think your disputes are going to be up to $10 million, then another range of institutions may be cost effective. 20 million, 50 million, 100 million, 1 billion, 100 billion. It really depends. And there are a lot of studies on this, which I'm not putting up on screen. But do your research to find out what's the likely size of the claim. Based on that, you might want to choose an institution that is appropriate in terms of cost for that likely size of claim. Will you be needing emergency relief? Will you be needing, let's say, an injunction before the tribunal has been constituted? Is that likely? For example, your client may be licensing certain rights, and you may need an order to suspend the use of those rights pending the dispute being resolved. And you might need to do that on an urgent basis, even before the tribunal is formed. For that, you could go to the courts, or you could rely on an emergency arbitrator. Some institutions have emergency arbitrators, others do not. So ask yourself whether you want to have that option. Does the institution have an expedited procedure, which means as opposed to taking 1 year or 2 years to complete, the arbitration has to be finished on a fast track, for example, 6 months, especially where the claims are lower in value. An expedited procedure is often useful. Does the institution have summary disposal or early dismissal of claims? In other words, can you get a quick resolution of the dispute without going through the entire process on the basis that the claims are bad in law, for example? This often saves a lot of time and costs. Again, some institutions have a summary disposal or early dismissal set of rules. Some institutions do not. Also ask yourself, based on research, who will these institutions choose as an arbitrator? Are they going to get someone local? Are they going to get someone from this jurisdiction or that jurisdiction? Do they favor their own locals? Do they favor people from a certain system of law? This might be important to you. This also feeds into sometimes cost. Cost is not always set by the institution. It's sometimes set by the arbitrators, and the arbitrators charge on an hourly basis. And in some arbitrators, in some jurisdictions, charge a lot more than other arbitrators in other less expensive jurisdictions. So who are these institutions likely to get? Time limits on the release of awards. Does the institution have a time limit? Some institutions, I've mentioned VIAC in Vietnam, require that the award be released within 1 month from the final hearing. That's very fast. It's speaking from experience, it's quite challenging sometimes. Is that the best thing? Should arbitrators be rushed in that way or forced to do that? The parties decide. You decide whether you think that's appropriate for your particular case. But ask yourself whether the institution has a time limit on the release of the awards. Does the institution, on the other hand, have disincentives to arbitrators who delay? I know the ICC does. If the arbitrators take too long, then their fees get cut down to disincentivize them taking too long in releasing an award, dragging their feet. Does the institution have scrutiny by its counsel? ICC and SIAC have this, FHKIArb doesn't. I'm not saying whether scrutiny is good or bad, but speaking from experience, it is useful to point out errors that the arbitrator may not have seen after looking at 16 drafts of the final award. You tend to miss certain things, and it's not something that you can take and show to your colleagues all around the office to say, could you please help me check this, because you're not allowed to due to the confidentiality of arbitration. So having someone in the institution help you check your award, cross the T's, dot the I's, is sometimes helpful. And different institutions employ counsel in this process. What's the level of assistance that these counsel will give to the arbitrators, because anything that makes the arbitrators' job of writing an award easier is very useful in speeding things up. We get to procedural order number 1. As I said, after the formation of the tribunal will normally issue a procedural order setting out how the arbitration is going to unfold. And there's usually a timetable that the parties have to follow. There are some arbitrators who are very prescriptive. They will have a very standard procedural order number 1, and they expect that the parties will strictly follow this and have maybe not too much say in what goes in and what doesn't go in. There are other arbitrators who are very light touch, who say to the parties, listen, you're both represented by very senior, experienced counsel. Could the lawyers go away and talk to one another and figure out what they want in this procedural order and what they want in this timetable? As counsel, as lawyers representing clients in future, you could try to be more proactive than your tribunal. Think about how the arbitration should unfold. Don't wait for the tribunal to tell you how it should develop. That's always a good idea, because then you take control of the process and you can speed up the process and achieve time and cost efficiency in the process for your client. Ask yourself whether you want pleadings or memorials. This is what I spoke about earlier. And if there's a tribunal of 3, you don't want the 3 of them going back and forth amongst themselves, deciding, should we give them more time and extend time to file this submission? On procedural matters, it's always a good idea to empower the presiding arbitrator to decide those procedural matters on his own. This will usually speed things up. You could, in fact, should, in this day and age, agree to communicate by email and use electronically exchanged documents as opposed to hard copies. And this is a very important point. In that entire timetable, fix the hearing and then move backwards. It's very important to fix the hearing first so that you know that everyone's available for the hearing, the parties, the witnesses, the tribunal, the lawyers. Fix that hearing. It could be 18 months down the road. It could be 6 months down the road in an expedited situation. It could be 2 years down the road, but whatever it is, fix it first and then move backwards from it. This is especially important if your tribunal is comprised of some very senior arbitrators with a lot of cases, with a lot of demand on their time, and you want to book them in advance so they can all be in the same place and available for your hearing. Consider setting a time limit for the award to be issued. Arbitrators usually will not want to put this in, but I'm saying this for everyone's benefit. The parties could very well agree in procedural order number 1 that this arbitration must conclude by this date, and the tribunal shall do whatever is required to achieve that objective. You could do that, and that gives parties certainty as to when the entire process is going to finish. It's not going to drag on for 5 or 6 years or longer. You could also consider setting a time limit for the award to be issued after the final hearing, 3 months, 6 months, rather than just leaving it to the tribunal to decide when it is ready to issue its award. If you put it up front, the tribunal goes into the final hearing, knowing full well that after that very last day of hearing, it's got X number of weeks, X number of months to release the award. And that has to build in scrutiny as well if the rules require scrutiny. So, as I said, fix the hearing, work backwards to all this. Fix the hearing, work backwards. Point number 4, invite agreement wherever possible. As I said, some arbitrators are very prescriptive. Other arbitrators are very light touch. I would suggest that arbitrators remember these principles. An arbitrator isn't a judge. You're not a court, and you shouldn't act like a court. Micromanaging should be avoided. Allow the parties to try and shape arbitration, to shape the procedure, because that's the beauty of arbitration. It's not a structured court process. It's become more structured in recent years, but the beauty of arbitration is that it was meant to be tailor-made to the particular party's industry and the dispute before the parties. So to take that away from arbitration does a disservice to arbitration. And arbitrators, in my humble opinion, should remember that. Allow the parties to shape with you how the arbitration process should unfold. Don't act like a judge and say, this is what I decide, you listen to me, I don't want to hear what you want, it's what I want. No, arbitrators shouldn't do that. And arbitrators should also remember that the party's time is actually more important than the arbitrator's time. Arbitrators may feel, oh, I'm very busy, I have to fly here, fly there, or do this piece of work, do that piece of work. But ultimately, they're being paid to resolve these two parties' dispute. And the parties may have their own concept of having the dispute finished in 6 months or 10 months because they want to get on with their commercial relationship or get on with their lives. And an arbitrator shouldn't say, no, sorry, that I can't do that. If he takes on the job, he should try very hard to meet the parties' expectations on how they want their dispute resolved and the time frame in which they want it resolved. Therefore, as an arbitrator, always invite and assist the parties to find an agreement and procedure. Don't just say, this is my decision on procedure. In other words, I think you should use pleadings. I'm more comfortable with pleadings as opposed to memorials. I think we don't need document production. Before an arbitrator says all that, listen to the parties. Try and get them to agree on how they want the arbitration to unfold. If you're a lawyer, if you're counsel, seek agreement from the other side on procedure. Reach out to them. And if you need time to do that, ask the arbitrator before he makes a ruling to say, I'm going to reach out to my friend on the other side and ask him whether we can agree to a certain procedure. Agreements inherently preclude or minimize challenges. You see, where two parties agree, it's very hard for one of those parties to then turn around to say, that wasn't fair to me, that was disadvantageous, that advantaged the other side, and not me, it was lopsided. It's very hard for a party to say that after the parties agreed. If a tribunal were to decide one way or the other, then the one side could very well say, oh, I'm disadvantaged. But if the parties come together and agree on what they should be doing, then later on it's very difficult for them to turn around and say it wasn't fair. And also, if the parties agree the timelines, it's more likely than not they will comply with those timelines, as opposed to timelines that the arbitrator thinks should be followed. Okay, you 2 weeks, you 2 weeks. But the parties may say, well, because of the shape of this dispute, I might need 3 weeks, and the other side, I'm quite happy to give him 3 weeks because it's a fairer way of doing things. The arbitrator should listen and try to get an agreement between the parties on the timing. Point number 5, list of issues. An arbitrator is hired to give a reasoned award. It's not just a decision, it's a reasoned decision. You have to give your reasons. And what does this mean? So we are taught in writing awards that first you state what the issues are. You then summarize the arguments and evidence by each of the parties on the issue. You decide the issue, you state your findings and ruling on each issue, and you explain why you came to that conclusion. That's a certain process that we are taught to follow. If we miss out an issue or we misstate an issue, we get it wrong, that might be fatal to the award. The award might be set aside, the award might be rendered unenforceable, or a court might send the dispute back to the tribunal for the tribunal to decide it, in which case you haven't finished your job. You're not entitled to be paid as an arbitrator, strictly speaking. Therefore, having an agreed list of issues is very useful. If you can have a list of issues that the parties agree, the 7 issues, we want the tribunal to rule on each of these issues, that makes it very clear for the tribunal what he or she has to decide. And there are some procedures, for example, the ICC procedure, which has terms of reference. And in those terms of reference, there's usually a list of issues. In other institutions, a list of issues used to be there in the rules, but for example, have been taken out of the SIAC rules. A list of issues, nevertheless, is a very useful tool. And even if the tribunal doesn't say, I need a list of issues, it's always a good idea to agree a list of issues with the other side so that you're more focused. This provides a convenient roadmap for the arbitrator when he writes his award, a checklist, as it were, so that he makes sure that he crosses all the issues, deals with all of them, states his ruling very clearly in all of them. It also assists in the document production phase, because the document production, a document production request has to be material to the outcome. And how do you know whether it's material to the outcome? Unless you know the issues that the arbitrator has to decide. So if the issues are very clearly spelled out, it's usually quite obvious whether a certain document ought to be produced or not. It also assists in the drafting of witness statements so that you don't have witnesses rambling on and on about things that are irrelevant. They can remain focused on the issues that the arbitrator needs to decide on. And in the examination of witnesses by counsel, it could be direct examination, could be cross-examination, or it could be examination by the tribunal, because the tribunal also has the ability to ask questions. Those questions can be more targeted to the dispute in question if you already have a very clear list of issues spelt out. We go on to witness statements. Now, as I said, witness statements are statements made by witnesses containing their direct evidence. So in simple terms, what it means is you're not going to get, if you have a witness statement used in an arbitration, you don't have to go through the usual, please state your name, please state your address. Right, I'm going to take you back to the 16th of May. Do you remember that day? Please tell us what happened at 8 p.m. that day. And the witness goes, well, at 8 p.m. I went into this shop and I bought. He doesn't have to say that verbally, orally at the hearing. It's all written down in a witness statement in advance. And everybody goes into the hearing having read that direct evidence. The obvious advantage is that it saves a lot of precious hearing time. Hearings are usually where, in the physical setting, the lawyers, the clients, which means the parties, the witnesses, the tribunal, all have to descend on a particular place and stay there for a couple of days in that country to have the hearing. So it's a very precious amount of time. The longer it takes, the more expense is incurred in terms of hotels and the hearing room and the transcribers. So you always try to minimize the hearing time, and witness statements achieve that because the whole direct examination of the witness is done in advance and it's all written down. They also make cross-examination a lot easier because you can say, well, Mr. Smith, could you turn to page 11 of your witness statement, paragraph 5? Now, this is what you say, and my question to you is this. So it really helps in the cross-examination to have the direct evidence of the witness written down. The big disadvantage is that these witness statements are almost always not written by the witnesses themselves. They're written by the lawyers. So this is not the witness's own vocabulary, not his own language. He might be writing in English when his native tongue is Russian, Indian, Chinese, or some other language. And the witness statement is recorded as a translation of his direct evidence, and it's read over to him in his native language, but ultimately it's written by a lawyer. And so you could have a situation where the witness goes, well, yeah, it's written that way, and I know I signed it, but you see, I actually speak Hindi, and it's not really accurate. And perhaps a more accurate way of expressing it is like this. And then, of course, the examiner will take issue with that and say, oh, you're trying to be funny, and you're trying to change your answer or change your evidence. And those are things that probably take more time and waste more money that could be avoided. So there is an obvious disadvantage to witness statements. However, the weighing up the advantages and the disadvantages, witness statements are frequently used in arbitration, in international arbitration today. They are common in many jurisdictions, but they're not universal. So there are some jurisdictions that do not have this. The structures, style, and format of witness statements can differ greatly. Some witness statements are written almost like a question and answer, in an almost question and answer format. Please state your name. My name is Mr. Smith. Please state your address. My address is whatever. And it says, I mean, that's how the witness statement unfolds. Other witness statements, paragraph 1, my name is Victor Smith. I come from this jurisdiction. I am an engineer. I was there when the oil rig was being set up. And it just goes on to tell the story as if it's written by the person himself. So the style and format can differ greatly. That said, witness statements do save a lot of time. But if you're using a witness statement, don't let it descend into a ramble of things that are not relevant to the dispute. Use that list of issues that I mentioned as a checklist for what should go into the witness statement. State what the witness will testify on in the first section of the witness statement. I am the engineer in charge of Project X. I will be testifying on the modifications to the project, who asked for those modifications, and how the modifications were achieved, and how the performance of the rig after the modifications improved as a result of the modifications. You state that at the outset, so when the tribunal reads this, he or she will know, this witness is coming for this purpose to address this particular issue. This is an example of how to make things easier for the arbitrator in writing the award. We now get to the last bit on hearings and post-hearing procedures. Very often, people will say a hearing is mandatory in arbitration. And that's because many laws require hearings unless the parties agree otherwise. But what does a hearing really mean? Is it just to hear the evidence? Is it to hear counsel explain their cases? Or is it both? And it very well could be both. A hearing is there to hear the witnesses, to challenge the evidence, and also to get clarity from the parties and the lawyers on difficult points of the case, or to hear dynamically from the lawyers their answers to certain questions, so that there can be an exchange of information between the tribunal and the parties or their lawyers on the spot. And sometimes writing all those things down will take several rounds of email communication to get across. But if you have a hearing and you have a conversation face-to-face, whether physically or through Zoom or in a remote hearing, it's very useful, because a perceptive lawyer can pick up, oh, this tribunal is disturbed by this issue, by this argument I'm making. Let me try and explain it in a clearer way to the arbitrator. Or the arbitrator may be asking a question, but the lawyer doesn't seem to get what he's asking. So the arbitrator has a chance of reframing the question and re-asking it in such a way that the lawyer understands it better and is able to address that particular question. So a hearing could be more than just for hearing the evidence of witnesses. It could be a chance, and very often is a chance, for the arbitrators to engage the lawyers and the parties on some difficult parts of their case. Always ask yourself, this hearing that we're going for, why do we need this hearing? What needs to happen at this hearing? So that you can best use the time at the hearing to do that. Don't just say, all right, we've got a hearing, let's just walk in there and see what happens. Always have an agenda to the hearing in your own mind as to what you want to get out of the hearing. What are the issues you want to address in the hearing? And if you're the tribunal, you'd also want in your own mind to set out what your agenda is for the hearing, why you're having this hearing, what are the difficult points or the difficult facts you're going to explore at the hearing through the witnesses or through explanations from counsel. If you're a party, if you're a lawyer acting for a party, ask yourself, do I need all my witnesses to come, or are some of those witnesses unnecessary for the hearing because their witness statements are just admitted and the other side says, I'll allow the witness statements in, I reserve the right to make arguments on what's stated in the witness statements later on, but I don't need to question this witness. It could be because I agree with what the witness is saying, or it could be because what the witness is saying is so completely wrong, it's a whole load of rubbish based on the contemporaneous documents, that I don't even need to ask him questions. I just show his witness statement to the tribunal, and then I have another document that says, signed by him, that says completely different. And I can tell the tribunal, come on, let's listen to what he wrote in his letter at the material time, not what's in his written witness statement, which is drafted by a lawyer. I could make that submission without questioning the witness. So ask yourself, which witnesses are required to attend for cross-examination? The more witnesses there are, the longer the hearing. So if you can limit your number of witnesses, you do save time and costs. Agreed time limits for each party. So you might have a 4-day hearing, you might have 6 hours of hearing every day, and in that 24 hours, do you want to divide the time equally? You have 12 hours, you have 12 hours, or divide the time in some other way? Because one side may only have one witness and the other side may have 8 witnesses. And is it fair to cram those 8 witnesses into the 12 hours? And some witnesses may require translation. Is it fair to say each side gets 12 hours, gets 50% of the time, when one side obviously needs more time to present its case because of the interpretation? So these things need to be worked out in advance of the hearing, and then the time is tracked throughout to make sure you're not taking up more time than budgeted. Opening statements in advance of the hearing or at the start of the hearing are often a good thing, because they set out a roadmap for what the tribunal is going to hear at the hearing, or what the tribunal will need to deal with at the hearing. But there should be time limits. You don't want lawyers going on for hours and hours. And maybe they could hand up skeletal, which means point form written arguments or written statements. They might even agree to use PowerPoint. Are you going to have oral submissions? Again, time limits on this. Are the oral submissions going to be supplemented by a handout or a PowerPoint, like I'm doing right now? And then it's always a good thing right at the end of the hearing for the tribunal to say to each side, have you had a full chance to present your case? Now, if they say no, then the tribunal ought to deal with why not. What if we gave you more time? What would you have done in addition? And maybe address that and diffuse that straight away, because that might be the source of a challenge later on. But if both parties say, yes, we've had a full chance to present our case, a reasonable opportunity to present our case, it's going to be very difficult for the losing side to then challenge the award on the basis that, oh, I didn't have the chance to do this and I didn't have the chance to do that. So that simple question right at the end is always very useful. At the end of the hearing, decide whether you need post-hearing briefs, post-hearing submissions to tie up the evidence that's been heard in the hearing, and Do you have a time limit for this, a page limit, point form? Don't not specify anything, and then one side puts in 10 pages and the other side puts in 1,000 pages, because that's only going to slow down the arbitrator releasing his decision. So it's always a good idea to specify this and agree this at the hearing itself before people go away and start writing. I get to the last few points. Video hearings. Now, in our COVID-19 situation, video and virtual hearings have come to the fore like never before. This saves a lot of time and costs, obviously. You don't have to fly. You don't have to pay the airlines. You don't have to pay for hotels. And that is a lot of cost when you include the cost of the tribunal, you include the cost of witnesses, counsel, all flying in. So a lot of money is saved, a lot of time is saved. There is one downside that I haven't put on the screen, and that's the time difference. So if, for example, I was hearing a case in Singapore and I was starting at 3 p.m. Moscow time, that would be, as it is right now, 8 p.m., 9 p.m. Singapore time. And then going on for 6 hours might be very taxing on the tribunal. Or does the tribunal say, all right, let's do this 9 a.m. my time, but it could be 3 a.m. your time. But I'm more important. So, I mean, things like that have to be worked out. So virtual hearings are not as simple as they sound sometimes. And also, what if one party says, one party might say, oh, very good, I love virtual hearings. I'm very happy to argue to a camera. And the other party says, no, I don't know how to do this. I don't know how to operate Zoom. I don't know how to use Microsoft Teams or Skype or anything. I'm a tech imbecile. And, you know, forcing me to do this is unfair. And therefore, you can't order me to have a virtual hearing. And of course, some rules don't even mention the possibility of a virtual hearing. So if a tribunal says, no, I order a virtual hearing, that could result in a challenge later on by one side saying that they didn't have a proper opportunity, a fair opportunity of presenting its case. Then you might have a situation where the tribunal is located in one jurisdiction and the parties are located in the same, well, one of the parties is located in the same jurisdiction and the other party is located outside that jurisdiction. Should you allow a semi-virtual hearing where the tribunal is sitting in the same room physically as with one side and then the other side joins in on a video link? Is that fair? Is that opening up the award to challenge? That could be a possibility. And witness coaching is something that's obvious. If you have witnesses dialing in remotely, they might have screens behind the camera telling them what to say. They might have somebody else in the room. And I've just heard a story from a Chinese lawyer, I believe, where someone was writing on a whiteboard behind the screen to give the answers to the witness. So the witness kept on looking there. Yes, the answer is yes. And you can't sometimes catch people if they're very, very good. Do you need two cameras in the room, another camera on the side to see whether the witness is being prompted? All these things need to be thought of. So a video virtual hearing does save a lot of time and costs. You have fast, you have cheap, but not necessarily good. Transcripts and recordings, a lot of the time this takes up, this costs a lot of money. Some companies make a lot of money out of this, and the arbitration industry relies heavily on these transcripts. But with virtual hearings, everything can be recorded, like this presentation, for example, and then the parties can go away and make their own transcripts of what took place in the recording. And there's one jurisdiction, for example, Malaysia, where this happens in court hearings. So there's a video of the court hearing, and then the judge works out with the parties how they want to make the transcript based on the video recording of the hearing. That saves a lot of time and cost, takes away the job from the transcribers and puts it in the hands of the lawyers and the parties to make a transcript that they both can agree on. Right? So that is something to think about in terms of saving money and saving time for a hearing. So here are some concluding thoughts. First, As we've seen, a good arbitration agreement is key. If you don't have that, then you have inherent problems and you have to try and navigate around those problems. So always start with a good arbitration agreement. Focus on principles, not just rules. There are many rules that institutions put out. Some arbitrators, like I said, like saying what you can do and what you can't do in an arbitration. But focus on these three main things: fast, good, cheap. Try to get a nice balance between all three and work this out with the other side in both parties' favor. Focus on solutions that make the process smoother. You don't get bogged down, you don't have challenges at every stage of the process. And focus on getting an agreed procedure where the parties agree on how to run the arbitration based on what the parties want within reasonable limits. You don't want to have an arbitration that goes on because the parties agreed to have it go on for 10 years. There has to be some reasonableness in the entire thing. These thoughts are by no means closed. There's always room for more innovations. People will always think up better ways, faster ways to run arbitrations. So what can you think of, especially using technology, to make arbitration fast, good, and cheap? This is a question that you can't necessarily address to court process because the courts want to retain a certain control over how they run their process. But like I said, in arbitration, the flexibility of arbitration is one of its strengths. And it's always open to counsel, it's always open to parties, always open to young lawyers to think of new ways to make arbitration faster, cheaper, and better, all at the same time. So that's my presentation. Thank you very much for listening. I'll now take any questions that you have, and I'm going to stop sharing this. And let me get to the chat. Do you have any questions for me?
Not yet. Maybe we can give participants several minutes to write it down. But
Sure.
I have a question. What was the most interesting case you had?
Most interesting arbitration case. As an arbitrator or as counsel?
Or as an arbitrator?
As an arbitrator. Okay, actually the most interesting case I've had as an arbitrator was not a very big case, but it was interesting because the tribunal was faced with the issue of whether there was an arbitration agreement to begin with. I can't give you too many details because of confidentiality, but the problem arose when one side said, I never signed a contract with the claimant. So the respondent said, I never signed a contract with the claimant. I signed a contract with the claimant's sister company, which had an arbitration clause, but I never signed a contract with this claimant. And there was a hearing to decide whether there was an arbitration agreement. And at the hearing, the claimant said, yes, I was not the original party, but because I paid for the goods, I got the banks to issue the LC. I then became the party, and I'm entitled to the arbitration agreement, to use the arbitration agreement. And we said, okay, well, how did you get your name on this particular document? Because you submitted a document with the arbitration agreement, which had your name and the respondent's name there. Oh, I just typed it in. And we went, okay, did you send this to the respondent? And the respondent said, no, I never received this. So the tribunal had to figure out whether there was an arbitration agreement. The tribunal ruled there was no arbitration agreement. Now, that's not so interesting, is it? But what's interesting is there was an appeal against the tribunal's decision saying there was no jurisdiction, no arbitration agreement. And the courts of this particular country, where the arbitration was seated, said, of course there's an arbitration agreement. You shall continue with the arbitration. And then the tribunal, which came from various countries, all had to get together to decide whether we resigned or whether we would continue with the case. And we unanimously decided to continue with the case based on the ruling that the court had issued, that there was an arbitration agreement and there was a contract between the parties. So it was interesting, it was bizarre, but it shows you that it's important to think about where you seat your arbitration. I won't tell you the jurisdiction. I'll tell you it's not Singapore. It's important to know where you're seating your arbitration. It's important to know the courts in that jurisdiction and what they are likely to do in a situation like that. And if the court in that jurisdiction declares as a matter of the law of that jurisdiction that there is an arbitration agreement, then the parties are bound by it and the tribunal is bound by it as well. So the tribunal can decide whether it wants to continue or, and if it continues, then it has to decide who wins or loses the case. And I won't tell you who eventually won or lost the case. I hope that answers your question. We have some questions now. From Vadim, in your experience, is bifurcation usually helpful in terms of time and money, or ordinarily it harms the efficiency of the proceedings and allows to delay arbitration? That's a very good question. Bifurcation means, well, it could mean two things. Do you bifurcate the issue of jurisdiction from the merits? In other words, decide the issue of jurisdiction first, then the merits, or it could be a bifurcation in terms of liability and quantum. In other words, decide who wins or loses, and then if the claimant wins, decide the issue of how much to pay or how much to order the other side to pay. There is no simple answer to that. It really depends on the facts. But generally, you would try not to bifurcate as far as possible as between liability and quantum. As between jurisdiction and merits, an early ruling on jurisdiction is useful because it gives the parties a clear indication of whether they want to continue fighting this. For example, if you rule there's no jurisdiction, it ends the case there. So it really depends. As far as bifurcating between jurisdiction and merits is concerned, you would really have to see whether you can decide the issue without hearing the full facts of the case. If you have to hear the full facts of the case, it's probably a better idea not to bifurcate and leave the issue of jurisdiction to the end and deal with jurisdiction and merits in the final award. If you're talking about liability and quantum, again, if the issue of liability, who is right and wrong, is very distinct from the quantum, then you may, if the parties also agree, decide to deal with liability separately. Because after that, when one side realizes it has to pay to the other side, that's when the parties could possibly go off and have a negotiation or a mediation to settle the amount that has to be paid. And then you don't need to complete the arbitration because it might be the subject of a settlement agreement that takes care of everything. We have another question from Natalia Lenkina. Do you know any jurisdiction where the arbitration awards are not set aside according to the legislation? What is your attitude to this practice? Okay. If I can sort of simplify that question, do I know any jurisdictions where, well, maybe I won't simplify the question. It's a tough question. There are jurisdictions, obviously, in the world where awards are set aside when they probably shouldn't be. There are also jurisdictions in the world where awards are not set aside when they probably should be. It really boils down to whether these particular jurisdictions are pro-arbitration or not. And I'm not just talking about pro-arbitration for the sake of being pro-arbitration, but being pro-arbitration in terms of the principles behind arbitration and what it really means when you say an award lacks jurisdiction, or that it offends public policy, or there's a breach of natural justice in how the procedure took place. There are certain established principles for the basis for setting aside awards in countries who are states parties to, let's say, the New York Convention, or countries who have adopted the model law on arbitration. And these are principles that would be applicable in one jurisdiction to another jurisdiction to another jurisdiction. And as far as possible, my own view is that courts should follow these general principles and look to the courts of other jurisdictions and see how they've decided. And there are more established jurisdictions which have decided more cases. I'm not going to single any out, but you know who I mean. So it's always a good idea for the less experienced jurisdictions to look at the more experienced jurisdictions in terms of upholding awards or setting aside awards, to get some guidance on how the principles for the setting aside of awards should be applied. I think there should be uniformity, some degree of uniformity in how these principles should be applied. In terms of countries which are model law countries, in terms of countries who are states parties to the New York Convention, and of course that New York Convention is not about setting aside; it's about enforcing awards. But again, the same set of roughly the same set of principles would apply in deciding whether to enforce an award or whether to set aside an award. So that's my attitude to that practice.
Thank you for your lecture and answering all the questions.
My pleasure.
Wish you a great day. Thank you again.
Thank you very much, and good evening from Singapore. I hope to see you all in person sometime soon.
Thank you. Bye.
Good night.